Good morning, everyone. Thank you for joining us and welcome to our webinar for the 2025 legal update by attorney Stephen Rappaport from Sachs and Caplan. We're so grateful to have you all here today. My name is Siobhan Gonzalez. I have the pleasure to be your moderator today, so I'm looking forward to that. Before we get started, I'd like to say thank you to all of you board members and CAMs out there. We appreciate you taking your volunteer positions seriously as leaders in this industry. We value your impact to our community and your associations at large. So we're grateful to have you here today. Before we get started, we have a couple of housekeeping items, okay? So obviously with the 2025 legal update, we value it's going to be a lot of information. We know you're going to have questions. We want your questions answered. So make sure you put them in the Q&A box only. All of your questions regarding today's presentation go directly to the Q&A box. It will be recorded and we will be able to answer them either during today's presentation or separately. You'll be able to hear from Stephen directly. Okay, so with that, also we want to make sure that the chat box is not going to be used. Again, use the Q&A box. For board members, this will serve you as a credit for today's class. So make sure you give our attorney, Stephen Rappaport, a couple of weeks to get those certificates to you. I also want to say thank you today for our sponsors who are making this event possible. Okay, so we're going to take a minute here to acknowledge our sponsors, give them an opportunity to introduce themselves. We're going to go ahead and get started with Daniel Baum. If you want to go ahead and introduce yourself from COA Solutions. Let's see if Daniel's here. Okay. Oh, Daniel, you're muted.
Siobhan, I believe he's not
Yeah.
here. I don't know if Peggy wants to say a word or you can
Oh, sure.
pass.
Okay. All right, yeah, thank you so much for that. So Daniel Baum, he's the CEO and founder of COA Solutions. You will get all of his information on the sponsor sheet. So even though he's not here in this moment, he can certainly support you and your association. So make sure to reach out to him directly. Up next, we have Ruthie from, she's the marketing director from Kaiser AC.
She's not here at the moment. I think, Siobhan, you could mention the people and then the ones who are here can speak when they say your name.
Okay, great. So let's start with Damaris Cabrera.
Good morning, everybody. Thank you, Siobhan, and thank you, everybody. Uh, my name, Damaris Cabrera. I'm the Business Development Manager for Clarkson and Barrick. We are a national elevator consultant company. We help owners. We are the advocates for the owners on the everything elevators. So we help to maintenance evaluations. We help them with the modernizations. We help them to get code compliance. And we bridge that communication with the elevator world that is so difficult because nobody has the expertise on the property management side, nor the condos, nor the managers. So it can get very complicated and sometimes very frustrating because it's one thing that there are promises broken, there are so many different issues that come with the elevators, and it's very hard to understand for all the people that is at the other side. The only way that they have is that they have to rely on what the contractor says. So we're here to help. So I'll share my contact information on the chat. And thank you, everybody. Have a good day.
You.
Wonderful. Thank you so much, Damaris. Okay, so up next, let's go ahead and hear from Peter Bloxam.
Good morning, everybody. My name is Pete Bloxam. I'm with CCTV Agent, and we also have with us Tatiana Yaquez, who is our CEO. And we provide security technology to communities, to businesses, and also government facilities throughout South Florida. So that can be from security cameras to door and pedestrian gate access controls. We would love the opportunity to talk with you about developing and implementing a technology solution for your neighborhood. Enjoy the webinar. Thank you.
Thank you so much, Pete. Appreciate that. All right, and let's see. I see Diana Ohlert from Best Roofing. Love to hear more about Best Roofing, Diana.
Good morning, everyone. Thank you so much for being here today. So yeah, I'm the Director of Business Development of Best Roofing. Best Roofing has been in business for 47 years now, and we'll be more than happy to help you with absolutely everything you need for your roof. Even if you have a question, anything, any simple question can help you to decide exactly what way to go with your roof. Remember, the roof is like one of the biggest investments that you have out there, so you want to make the right decision. We do repairs, we do roof, we do recovery maintenance programs, and we cover from the single family home to industrial, commercial, high rises. So we can do absolutely everything. We do have the manpower for it. We're 400 employees. So if you have any roofing needs or any roofing questions, I'm here for you as well. So I'm going to put information on the chat box. Thank you so much for being here today.
Wonderful, Diana. Thank you for sharing about Best Roofing. Okay, up next we have Dylan Pena from PD Concrete.
Thank you very much for the introduction, Siobhan. Happy Friday, everyone. I hope everyone's having a great morning so far. So I'm the business developer for PD Concrete Specialist. We're proud to be in business for over 20 years. We specialize in concrete restoration, waterproofing, and post-tension cable repair. We also assist with the 40, 50, 60-year recertification process as well. One thing that sets us apart, though, is that we do not use subcontractors. We only use in-house employees. This is to ensure quality work and accountability for every step of the way. Now, we only have 2 offices in South Florida, one in Aventura and one in West Palm Beach. If you have any questions, I can leave my information in the chat box below. Thank you very much, Siobhan, and everyone have a happy weekend.
Wonderful. Thank you, Dylan. Okay, let's hear from our next sponsor. It's going to be Bob Aleka.
Well, good morning, everyone. Thank you for that introduction. Bob Aleka here with Faster.io. We provide streaming TV, internet through our fiber optic infrastructure. What makes us different is that our parent company is a Tier 4 data center. So you get all the security and the upgrades from a Tier 4 data center right at your property. In addition, you can take your TV or streaming TV anywhere in the world with you, change your address, and you'll get the locals of that zip code. And then when you come back to the property, you change your back and you'll get the locals of wherever your property is in Florida. So if you're looking for a proposal, if you're looking to explore a bulk option, please give me a call and we can further discuss. And no property is too small for us. So enjoy the class and we'll see you on the next round. Thank you.
Wonderful. Thank you so much, Bob. All right, up next, we have Shani Haas from, she's the marketing manager from Munyon Contracting. Shani, we'd love to hear from you.
Hi everyone, I'm Shawnee. I'm from Munyon Painting. We are a family-owned and operated business, and we've been servicing all of Florida for going on 75 years now. We're proudly serving communities across Florida with high-quality interior and exterior painting services for both residential communities, high-rises, and commercial properties. We're not just about fresh coats. We're about long-term protection, curb appeal, and helping boards and managers keep their communities looking sharp and well cared for. I'm really excited to be here and I look forward to connecting you all and have a great weekend.
Thank you so much, Shawnee. Okay, let's see. Up next, we have, I believe, Dana Hillman from Pack on the Go.
Hello, everyone, and good morning. My name is Dana. I work at Pack on the Go, and we are a contents management company. And for those of you who aren't aware what contents management is, when disaster strikes and there's a fire or water in a building, in a unit, in a home, the restoration comes out and dries everything out. But what happens to all of your treasured belongings? We are the company that comes in and takes care of those so that when the floors need to get redone, we pack everything up, we take it to our facility, we clean it from water, mold, soot, smoke, whatever might have happened to it. If it needs cleaning, we store it. And then when your restoration is complete, we bring everything back and unpack it and put it exactly where it was. It's a fabulous service. We're usually covered by insurance, and we are great people to call whenever you have an issue with water, fire, or mold.
Wonderful. Dana, thank you so much.
Thank
So
you.
yes, pleasure to have you here on the webinar today. But we do have other sponsors who have made this webinar possible. We want to take a quick moment to acknowledge them. They could not be here presently virtually with us today. However, we want to make sure we mention Ben Friedman. He's the president of City Quiet Windows and Doors. Of course, we have Jamie Gelfand from First Citizens Bank, who also sponsored this event, as well as Brooke Cavender, Florida Business Development Manager from Southwest Elevators, Rick Hogan from Velocity Services Group, Nicole Johnson, partner at Hafer, Guillermo, who is for your railings over at Alnec, Don Miller with the Paving Lady, of course, Peggy West, who is out on injury, but she is the CEO and organizer of Market Smart and Florida Condo Vendors for You, who makes all of this possible. And of course, we want to make sure that we hear from Vinteum. As Peggy would say, the wind beneath her wings. So let's hear more about Vinteum software from Laura.
Hi guys, how are you? My name is Laura. I'm one of the account executives here at Vinteum. So what do? We help more than 300 communities across the US with software and services for HOAs, condominiums, cooperative associations, property managers, and as well property management companies. We help them, having a software or platform to manage their community, to manage their amenities, to have a better communication, and most important nowadays, to comply to the new Florida law update. So we also help them with the website, a password protected portal. We provide an excellent personalized service as well as a really good customer support, ongoing customer support. So if any of you guys here, board members, property managers, or anybody who is working right now with an association or a community, not only in Florida, but throughout the US, we've been here in business for almost 11 years. So if you guys need someone to help you guys out with all of these, just let us know. We're here to help. We're going to go ahead and share our information through the chat. And yeah, thank you very much.
And just to add, you guys, nice to meet you. My name is Amanda. I'm the head of marketing. We're going to talk after Steven's presentation to explain to you how in practice you can be compliant with the website and portal until January 1st. So if you'd like to, please stick around and see in practice how to be up to date with the new law. Okay? Thank you.
Wonderful. Thank you so much for that. And so last but not least, of course, we are one of the sponsors for today's webinar as well. So again, my name is Siobhan Gonzalez, business developer at United Professional Engineering. We are a full service structural engineering firm. We've been serving South Florida condominiums for over 20 years. So we are here to serve you in all of your engineering needs, from milestone, recertification, phase 1, phase 2, concrete restoration and repair. We do painting projects, roofing projects, pool decks. There's still a lot of questions around engineering. When do you need to call an engineer? When is an engineer necessary? Too many times, we pick up the phone gets picked up and they call the GC first. So if you have any questions on any projects, we are offering all of the viewers here today complimentary consultation. So we're here to serve you. We just want to be that resource. So if you have any questions, I'm here to serve you. let's go ahead and get to it. Our 2025 legal update. Stephen Rappaport, attorney, is going to be taking us through this today with Sachs, and Caplan. Stephen, you have quite the impressive bio. I'm excited to work with you today.
Glad to be here.
I would love for you to tell us about who you are. I know that you are a pillar in the community here in the condominium world.
Okay, I'm going to say now. Hot out there?
Can we mute?
Yeah, can we?
Peggy, I think your audio's on.
There we go.
Wonderful.
All right. Okay. So yeah, my name is Steve Rappaport. I'm a partner at Sachs Caplan. I've been practicing for 23 years. Community association work is all I do. It's all I've ever done since I left law school. So I'm happy to be here. Always happy to do these legal updates. Siobhan, I'm going to be counting on you as the moderator to walk us through this. So you let me know if you want me to just start it off, or do you have any other opening remarks?
Wonderful. Yeah, no, this is great. Thank you so much. And I know that this legal update it's effective as of July 1, correct?
Correct.
Man, so this is, it's fresh, it's hot. So we are certainly looking forward to hearing from you. Let's go ahead and get right into it.
All right, so to kick it off, there's a few topics that we're going to cover today, mainly condominium association related. First of all, I do have to apologize a little bit in advance. I'm a little under the weather today, so I'm going to try to power through this as best I can. Losing the voice a little bit, so again, apologies for that. But this might be a little bit more of a briefer legal update than what you're used to, but I'm sure we'll have tons of questions. If you do have questions, I will do my best to get through them all. We're going to go over HB 913. That was the big condo bill from the last year's legislative session. So again, if you're in the HOA sphere and you're here at the end, if you have any HOA related questions or anything like that, we can certainly try to address non-condo questions at the end. But I'm going to go through the main points of HB 913, at least to kick this off while we have some time. So HB 913 really got into three kind of major subtopics. So on the one hand, it dealt with community association managers and imposing some additional requirements on managers and management firms. The second big subtopic is the milestone and the SIRS, the Structural Integrity Reserve Report. So you have the milestone and SIRS, a few minor tweaks to that in the last session. And then the third overall general topic is sort of your corporate governance meetings. They did a lot of stuff on electronic voting and virtual meetings. We'll get into that a little bit later in the topic. So let's start it off with some of the changes that they made to the Community Association Management Statute. That's Chapter 468. So again, Chapter 718 governs condominium associations specifically, but you also have to remember that sometimes we need to look at Chapter 468, which is the Community Association Management Statute, and imposes certain requirements on the managers, management firms, their license requirements, and so forth. So a few of the things that they did in 468 in the last session is they put in a prohibition that if you had your license revoked, you will become prohibited from any ownership interest in a management company for 10 years from the date of revocation. So I'm sure that's going to apply to absolutely nobody that's on this call. I'm sure no one here has ever been revoked or suspended. Everyone's doing a great job. But just be aware that if for whatever reason you or a colleague have their license revoked, you're basically kind of barred from being in the industry for 10 years, and you kind of have to wait it out for a little while. They've imposed some new requirements to create an online account with the DBPR. The DBPR, of course, the Department of Business and Professional Regulations. That's the Tallahassee Department under the Division of Corporations that governs specifically over your licensing requirements. So now all CAMs and CAM firms are going to have an online presence. And for all managers, you must identify the firm for which you work. You must identify each community for which you are an on-site manager. And if any of that information changes, you must update it within 30 days of the change. If you're with a management firm, the firm now must identify all of the managers that it employs. So again, more along the lines of transparency, you've seen over the last few years, there's been this drive towards records keeping requirements, transparency, and violations for, and penalties for violations of the law. That seems to be where the law has been trending since about 2021, 2022. More openness in terms of records, more openness in terms of transparency, conflicts of interest, which we'll talk about in a little while. You're seeing the legislature kind of pushing, both even in the HOA world, although this is a condo bill, you're seeing the legislature legislature push towards requirements for more openness, more transparency, more records being kept. Um, Kind of along those lines, one of the things that they've imposed now for community associations, any contract between an association and a CAM or a CAM firm must include a provision that states that the association manager shall abide by all professional standards and record keeping requirements. So, in other words, it's not like you didn't have that requirement anyway, but now it's being forced to be put into your actual contract with the community association. So, if you're on the board side, you need to make sure that your community association manager has that in their contract. If you're on the management side, you need to make sure your contracts have been updated to include those new requirements. Okay. There's a question here. How does the condo association access the information you just talked about? I believe that information will be posted on the DBPR's website. There probably will be a portal through the DBPR's website. I'm not sure if it's up and functioning right now. I believe it was required to be started around October 1st, so they should be up there. But check out DBPR in Tallahassee. It should be up there. Okay, excuse me. A few other requirements before we move on to the milestone reports
I'm telling you,
for CAMs
it's
and
clear
CAM
they're
firms.
not quoting, they're not doing apples to apples. We need to get them
I think Tatiana needs
give
to
us
mute.
the quote. Like at this point, they have
Anyway, I'll keep going. So for CAMs and CAM firms, if you might recall, a year or two ago, they put in a requirement for HOA managers that they must attend at least one board or membership meeting per year. Kind of a strange requirement because it seems to me that the job of the manager is to be there for all meetings, or at least a majority of the meetings, but they had a requirement that for HOA managers to attend at least one meeting a year. They changed that to be community association. So they changed the homeowners association manager to community association manager. So now, whether you're condo, whether you're cooperative or HOA, your manager is now required to attend at least one board or membership meeting per year. Again, as a practical matter, I would assume that they're attending all of your meetings, or at least a vast majority of your meetings, but there is a requirement now for a one meeting per year. Every CAM or CAM firm assigned to a community must provide its members with the following information, and it can be posted on the website: name, contact information, and hours of availability, as well as summary of duties. So that all needs to be made available on the association's website, or to at least to be sent out to all the members of the community. The name of the manager or management firm, their contact information, hours of availability, assuming you have them, and summary of duties, and that this must be provided to the membership within 14 days of any change in that information. Also, every member is entitled to a copy of the contract between the association and the management firm. Now, of course, that would have been part of your official records, which any owner could have requested anyway, but they've again imposed this as an additional requirement that if any owner requests it, you need to provide it to them. So I would assume that that now means that for the management contract specifically, if an owner requests it, you should just give it to them as opposed to making them wait the 10 business days for the inspection. And then finally, in 468 on conflicts of interest, they've changed some of the conflict rules so that if you are with a management firm that has an ownership interest in some other type of industry, so for example, if you're a management firm that also runs a landscaping company, or has principals in the management firm that owns a landscaping company or some other type of company, website company or whatever, you need to disclose that to the association. And if you do not, then the contract between you and the association can be voidable. So the board, if they find out later that you have an interest in another company and another vendor relationship, and you did not disclose that, that contract can be voidable by the board without regard to what the termination rights are in the contract itself. So again, you're seeing this push towards conflicts of interest, making sure that these associations know of any other relationships that your manager or your management firm has with other vendors. Okay. As you can tell, I'm losing the voice a little bit, so I'm going to try to speed through some of the more important stuff and really cover the main stuff that I think you need to know, and then we'll maybe, Siobhan, if you can jump in with some of the questions as we go along.
Wonderful.
On milestone reports, what's it? Go ahead, Siobhan.
I would say, Steve, we do have a question here.
Sure.
From it says, does the one sentence required to be included in management contract apply to contracts entered into prior to 7/1/25?
That's a really good question. The general rule of law is that a statute does not apply to retroactively affect previous contracts unless the contract takes that into account. So I would say maybe best practices is to get with that company and see if they can do an addendum to the contract to include that language. But I would say that there's no obligation for them to go back and put it in now. But when you go to renewal, obviously the renewal of that contract will need to contain that language.
Oh yeah.
good questions.
Yeah, good question. Great response. Thank you so much.
Yeah.
We do have another question. It says, if we only have a CAM and not a management company, must their contract be placed on the website, which shows remuneration?
Yeah, there's certainly an argument to be made. I mean, it's certainly a record, an official record that's open to inspection, even with their pay, that that gets into a completely different topic. But usually payroll information is protected and privileged from being seen. But if that payroll information is identified in some other record, including the management contract, then that is going to be open to inspection. Whether it's required to be posted on the website, I think there is some language in the statute that says that a list of contracts is what's obligated to be on the website. I think, there's a slight difference between HOA and condo on that issue. So that might be something I might have to get back to this person if you want to email me offline, or if you want to consult with your association's counsel, because it is a little weird where they have one statute requires you to post the actual contracts and one requires you to post a listing of the contracts. But yes, I mean that contract with that payment information is going to be an official record. So whether it's posted on the website or somebody can request to see it, it is going to be open to view by the membership.
Thank you, Stephen.
Okay. All right. On milestone inspections, they did a few minor changes to that this year. They didn't kick it down the road like we thought they might. They didn't change the rules on anything. They've given some opportunities to extend the time frames a little bit in certain circumstances, which I'll get to in a second. But really the big change they made this year was they clarified the three-story issue, and they have now said that the milestone report requirement applies to 3 habitable stories. They added the word habitable into the statute. So what does that mean? Well, if you're a high rise, you're probably gonna have more than 3 stories no matter what. So you're gonna have to do your milestone report no matter what. This really addresses the situations where you have these townhome communities where, let's say, the first floor is the garage, and then you have the second and the third floor are your living space. And so a year ago, we would get questions as to whether or not those types of townhome communities would have to do the milestone report. And we would tell them, yes, you do, because that opening space on the bottom, even though it's only a garage, is still a story, and therefore you are a 3-story structure. Now that's no longer the case. Now they've clarified it to be 3 habitable stories. So if you are in one of these townhome condominiums and your first level is a garage that's not part of your living space, and your second and your third story are living space, you are not now obligated to do the milestone report, because you are not 3 habitable stories. You're only 2 habitable stories with a garage or carport on the ground level. So that's a big change in the law. It imposed a new requirement that a licensed architect or engineer who bids to do the inspection must disclose if they also intend to bid on any of the recommended repairs. So trending towards that whole conflict of interest closure type of theme that we've been seeing in the legislature for the couple of years. If you're doing the milestone inspection and you think you might be interested in doing the repairs that are effectuated from inspection, you need to disclose that to the association, because there could be a potential conflict there. Because can you, on the one hand, be saying that you need to do all this work, and then, by the way, I'm going to do this work for you? So you need to have that conflict disclosure there. And it prohibits any architect, engineer, or contractor that bids to do the repairs to have any interest in the company that did the milestone inspection, unless that's been disclosed in writing to the association. So again, if you are a company that does both the inspection report and that is also planning on doing the work that results from that inspection report, you need to make sure to disclose that relationship to the association. And failure to do so will make similar to the management statute that we just talked about, will make the contract with that vendor voidable by the association. Okay. All right. I don't see any additional questions on that. All right. So let's talk about official. Let's see. Financial reporting, website information. So on website information, as of January 26th, so this is one of the few things that does not start in July 1st. In January of 2026, condominium associations of 25 units or less will now have to have a website for their association. So it used to be, I believe, 150 units was the previous requirement. They've now dropped it down to 25 units as of January 1 of 2026. So I know Vinteum is going to be giving a nice presentation at the end of this that's going to talk about how you can comply with that. So that will dovetail nicely into the end of this presentation. But be aware, if you're a smaller condominium association, you might have been able to get away with not having your website if you were under 150 units. Now, if you have to be under 25 to avoid that requirement. Okay. Records to be maintained by the association. I think this was always the case. They added financial statement and annual budget to the records that are required to be maintained on site. That was always a requirement. You were always required to maintain all of your financial records. They're just listing these things very specifically. I'm not sure the point of that, but again, making sure that you have your budget and your most recent financial statement available to the membership for an inspection request.
Stephen,
Yeah,
just let's go back a little bit. There was a
sure.
question, I think it's important. If you have only a CAM and not a management company, must their contract be placed on the website which shows remuneration?
Yeah, I think we covered that. And again, I think it comes down to whether the statute requires that they post the actual contract or the listing of the
Mm,
various contracts. And that's something that's very specific in the statute that I don't have in front of me. So it's something that, again, if that person wants to reach out offline, I'll be happy to look up the statute and address it. Or if they want to get with their association's counsel, um, they can do that. But the statute is sometimes very strangely worded, and I think it talks about having a list of contracts on the website, not necessarily every single contract. So, but that's something I can
okay.
follow up on offline afterwards.
So, Stephen, I do see a question related to the milestone.
Okay, perfect.
It's saying, can local government impose milestone on two-story over the state?
Yeah, I said, they call it home rule, a locality if they want to, and certainly before the state even gotten involved in this, the city of Boca Raton had their own certification requirements. I believe Broward County and Miami-Dade County had their own certification requirements. So certainly a locality can absolutely impose their own requirements for that particular county or city. In addition, this is what the state is mandating statewide, but certainly you can see certain cities and counties doing their own thing. Absolutely.
Yep. Thank you, Stephen,
Okay.
for shedding light on that. And I've seen it too, where
Yeah.
these municipalities, it can be, it definitely depends on the municipality. So, yep, that's a great observation. Very good question. Thank you.
Okay. All right. Financial reporting. They made a couple minor changes to the financial reporting statute this year. So it used to be that once you had your financial report, again, that's your audit, your compilation, your review. If you're over 500,000, you do your audit and so forth. So your financial reports that you do at year end is based upon your estimated revenues. The previous statute said that once the financial report was completed, you had 120 days deadline after the completion of the report to provide it to the owners. They've now increased that to 180 days. So it's giving you 180 days after the end of the fiscal year to provide your financial report to the ownership. And the funny thing, they've changed a huge glitch that they put in. I think it was either 2 or 3 years ago. They really messed this up. They changed an or to an and we wondered if it really had any effect, but it did. What they did a few years ago is the old rule used to be that you could either provide the year-end financial report to the owners, or you could provide them with a notice that the report was available upon request, and that if you were requested to provide it, you would have to give them a copy. So you either mailed it out to everybody, or you mailed out a notice saying, "Hey, everybody, our financial report's done. You can have a copy of it if you'd like a copy of it." Well, a couple years ago, they changed the or to an and, which made absolutely no sense. You had to provide a copy of the report, and you had to provide a notice that the report was available upon request. Well, how does that make any sense? If I'm already providing you with the report, why do I have to already also provide you with a notice that the report's available when I've already mailed it to you? So they've changed the and back to an or. So one thing the legislature did good this year, they changed the and to the or. So now it's back to the old rule where you either provide the report after, now it's 180 days after the fiscal year, to all the membership, or you provide them with a notice that the report will be available upon request. If an owner does request a copy, it can be mailed, hand delivered, or electronically delivered. And you can also post it on the website. It requires an affidavit by an association officer attesting to compliance with the notice requirement. And it increases the threshold. This is important. So remember that the membership can vote to reduce the reporting requirements on an annual basis. So if you're required to do an audit, you can get a majority vote of the membership to go down to a review or a compilation. But it used to be that you only needed a majority of those voting as long as you had a quorum, a simple majority of the quorum. Now it requires a majority of the entire membership of the condominium to change that from the audit to either the review or the compilation. So it's giving you a little more time to get it done, but it's increasing the required vote in order to go down to that lower threshold of a financial reporting report. So, any questions on the financial reporting requirements? I don't see any. Another topic they addressed, investment of association funds, requires the board to use its best efforts in making prudent investment decisions on investing funds, including reserve funds, specifies that an association may invest reserves without a membership vote. Now, I don't know how this changes what the law used to say. I think this just codifies what was always kind of understood. If you had reserves and you wanted to invest them in a safe investment like a money market or savings account or something along those lines, you always had the right to do that without a membership vote. The board always has the right to make reasonable and prudent business decisions. Now, you couldn't go off and put it in the stock market or any risky investments like that, but in my opinion, you always had the right to invest your reserves or invest your funds in non-risky, reasonable investments. This, for some reason, I guess the legislature felt they had to put it expressly in black and white in the law, which is great. It confirms kind of what we already knew. But just so you are aware, you don't need some sort of membership vote to take your reserve funds or your operating funds and invest them as long as you're making reasonable and prudent investment decisions. So money markets and things like that, don't throw it in the stock market, throw it in reasonable and prudent investments. Okay. Now the fun stuff. This is the part of the statute that they really messed with this year and is extremely frustrating. But we'll go through a little bit of this because now we're going to talk about video conferencing of board and membership meetings. So ever since COVID, of course, for the last 5 years or so, many associations have been either taking their meetings off into the Zoom world. They've either been going to online meetings, Zoom platform meetings, or some hybrid of some in-person and some Zoom meetings. So there are now some new rules if you're going to continue to use Zoom meetings for a condominium association. Again, these are condo specific requirements. This does not affect HOAs yet, although again, the trend in HOA world always seems to be to mirror the Condominium Act. So if you are here from HOA, this may be coming down the pike, but for condos specifically, board meetings can now be held. So we always felt this was the case, but board meetings, they have now acknowledged, can be held in person or by video conferencing. If you do by video conferencing, a notice must specify that the meeting will be by video conferencing and must include a hyperlink or a conference telephone number along with a physical location for members to attend. So, big important difference here. If you are going to have a board or membership meeting by Zoom or by some other remote communication, you must now also have a physical location to have that meeting. There is now, for condos, no longer an all Zoom meeting option. If you're going to offer Zoom as an option, you now must also have a physical location for the meeting where people can attend in person. So the legislature apparently thinks that Zoom is okay, but they don't think it's okay enough to use entirely for a meeting. That you must now at least have a hybrid where you have a physical location, people can attend in person, but you can offer the Zoom for those that either cannot or do not want to attend by Zoom. If you do use your meeting by video conferencing, you must now record that meeting. So now it's not enough that the owners have a right to record your board or membership meetings. If you are going to have a Zoom meeting, you must now record that meeting, and that recording of that meeting will become an official record that must be kept by the association. So big, big, big difference here. So I don't know if this is going to make things more difficult for associations to hold remote communications. I don't want to discourage associations because Zoom does work very well for meetings, but just understand that if you are going to continue to use Zoom for your board and membership meetings, you must now have a physical location. So the all Zoom option is no longer an option, and you must record it, and you must keep that recording as part of your official record. So if that's going to become a deterrent for any associations from holding Zoom meetings, understand that there was no obligation for you to do that in the first place. This was all really convenience, and your only obligation is to hold your meetings in person anyway. You have the right to allow people to attend by conference call. You have the right to allow people to attend remotely. There's no obligation to do so. So if you decide after this to say, you know what, we don't want to record our meetings, we don't want to keep those recordings, we're just going to go back to in-person meetings, and if you can make it, great. And if you can't, too bad, so sad. You have the right to do that. You have the right to go back to all in-person meetings. I think the Zoom thing is a great thing. I don't think that there's really anything to be worried about in terms of recording the meetings. And it's not like you're doing anything where you want to keep anything hidden, but just understand that those are now going to be new obligations that we must open our meetings to recording and keep those recordings as part of our official records. In terms of membership meetings, again, membership and board meetings, same rule is going to apply. If you're going to have a Zoom or other remote meeting, you must have a physical location. It must be recorded. The recording must be kept. But here is the interesting twist when it comes to the annual meeting of the members, which makes absolutely zero sense. And I mean this, it's absolutely zero sense. The new rule is for your annual members meeting, not a board meeting, for your annual members meeting where you have your election of directors, if you do it by Zoom, not only do you have to have an in-person function, an in-person location, not only do you have to record it, not only do you have to keep that recording, but a quorum of your existing board members must be physically present at that physical location for the annual meeting. I'm going to pause for a second and let that sink in terms of how little that makes sense. This is an annual meeting of the members. Prior to this law going into effect, the board members did not even have to attend the annual meeting. You just needed a quorum of the members. In fact, you just needed 20% of the members as a condo association to cast a vote in the election to have a valid election. However, now for your annual meeting in a condo, if you're going to do remote communication, a quorum of the existing board must physically be present at that physical location for the annual meeting. So just be aware of that. It makes absolutely zero sense, but that is now a new requirement for condo elections and annual meetings. Okay. Moving on to another thing that makes absolutely zero sense. You know, they called this Condo 4.0 because this is the fourth year since the unfortunate Surfside incident. So it seems, you know, every year Condo 2.0, Condo 3.0, this is Condo 4.0. I call it how the legislature messed up the Condominium Act this year. That's my subtitle for this legislation. So they've messed up virtual meetings, so now we're going to talk about budget meetings. So if many of you may recall, for your budget meeting, there used to be what was called the 115% rule. And what the 115% rule said was if you adopt a budget in any year that is 15% more than the previous year's budget or 115% of the total budget from the previous year, excluding reserves and excluding insurance premiums, so excluding the big things that would likely increase your budget the following year, excluding those items, if you have a budget increase of 15% over the previous year's budget, there was this whole complicated substitute budget process that would be triggered where the owners would have a right to petition for a substitute budget to consider. So the old rule used to be that if you had this extremely high budget that was over 15% of the previous year's budget, you would have to allow the members, I think it was within 21 days of the budget meeting, to petition for a substitute budget. And if the members got themselves together and actually organized themselves and got a notice out and put together this substitute budget and presented it to the membership for a vote, then the members might have a right by majority vote to adopt this quote unquote substitute budget that the members would have an obligation to put together. And my point of dragging this out is to basically say that in 23 years of doing this, I've never seen it done, never even seen it attempted. So it was usually one of these jokes that it never happened. Well, they changed it. So now the 115% rule is it's no longer a burden on the owner to present and petition for a substitute budget. What the statute now says is that if a board proposes a budget that exceeds 115% of the previous year's budget, then the board is now required to simultaneously prepare a substitute budget that does not include any discretionary expenditures that are not required to be in the budget. So again, let's sink on those words for a little bit. What in the world does that mean? We're obligated to present a substitute budget that does not include any discretionary expenditures which are otherwise not required to be in the budget. Well, what are discretionary expenditures? The statute, they don't define that. What's a discretionary expenditure? Can anybody name me something that might be a discretionary expenditure? My understanding, and I'm not an accountant and I'm not a property manager, so I don't do your budgets on an annual basis, but my understanding is that your budget takes into account the expenditures that are necessary for your association to run, right? Takes into account your landscaping, your management contract, all the funds that you need to accumulate in order to pay all of your necessary expenses. So to me, I don't know that there are really any discretionary expenditures in your budget in the first place. If there are, I suppose this now obligates you to have some sort of second budget to present to the membership to consider that doesn't include those discretionary funds. I suppose if you have a line item for parties at the end of the year for the holidays, maybe that's a discretionary expense that you don't absolutely need to have. I can't really think of anything offhand that would qualify as a discretionary expenditure that's in your budget, because again, budgeted expenses to me are things that are necessary to operate and run your association. But just be aware that you probably will need to consult with your accountants and your association's attorney when it comes budget time as a condominium association if your budget's going over 15% to deal with this issue. The simple solution, make sure your budget doesn't go over 15% of the previous year's budget. Get to 14.9999% as a maximum cap. Try not to go over that 15%, and then you don't have to worry about this. But again, nonsensical things like this that they're putting into the legislation, it's unfortunate. I mean, it begs the question, how do members vote on this at a board meeting? This isn't a membership meeting, it's a board budget meeting, yet you're giving the owners the right to vote on a substitute budget at a board meeting. How do owners even vote at a board meeting? I assume they would have to have a quorum of the membership attend the board meeting, which you rarely get at a board meeting. So I don't know if this is going to have much of a practical effect, but just be aware that this does change the game a little bit if you are going to have a budget in any year that is in excess of 15% of your previous year's budget.
So
Okay.
Excuse me, Steve, I think you have quite a few questions, Siobhan.
Excellent.
Yeah, they are coming in.
All right,
So
let's go for it.
yeah. So a question here regarding budget is can the SIRS pooled reserves be used to pay for a new SIRS line item that is not currently listed in the current SIRS line item? Can it be used to calculate the current reserves?
That is a great question. And usually when I get a question like that, my canned answer is that is something to consult with your structural reserve advisor on because they probably know the answer a little bit better. My understanding, I'm going to get a little bit into pooling of reserves. That's actually my next topic. But from the legal perspective, my understanding is that if you are pooling your structural integrity reserves, you can use those pooled funds for any of the structural integrity reserve purposes. If you've updated your SIRS report to include new SIRS items, then I think you would be able to use those funds for those new items. But I think it might, if you're adding new items, it might update the amount that you need to continue collecting in that pool in order to cover all of those items. Again, that's more of an accounting and reserve specialist question, so I'm probably going to punt those types of questions to your accountants or to your reserve specialists. But from a legal standpoint, if you're pooling those reserves, I think the legal answer is yes, you can use them for any of those pooled purposes, including if you're adding new items to it. But I think that may change the game in terms of calculating the total amount that you may need in that pool. If you're now adding new items, you may need to update that SIRS report, and you might need to start collecting more on a moving forward basis to take that into account to make sure you have enough funding in that pooled reserve to cover all those new items. So unfortunately, that's probably the best I can give you on that question without being a reserve specialist.
Okay, yeah, thank you so much. And then another question regarding budgeting and accounting is for the budget increase of 115%, is that condo or HOA or both?
Condo only. HOA never had that restriction. That was always a condo issue. It was always an issue that never came up because it used to be that the burden would be on the owners to try to basically overturn the budget and present their own budget. Now, like basically what they're doing is they're taking that burden from the owners and putting it back on the association to require the association to present this other substitute budget. But again, condo only. This whole law, this whole HB 913 is a condo law, which is why I said for HOA members that are here, unfortunately, there's not a lot of update to tell you other than the good news that they didn't change the law this year for you, but we can take HOA questions at the end, and I'm happy to take any HOA general questions if we have time at the end.
Wonderful. Thank you, Stephen. So as far as the budgeting, now there was a quick transition from like the website, the conferencing, and video to the budget. There are lots of questions still about the meetings. I know you covered a lot, and we'll be sending slides regarding that. And I think the great part is that as far as like meetings and the website, those are a lot of the questions regarding that. I think and then having Vinteum after, because they make sure that everything is compliant. I think that's really cool. So we're loving these questions. Please make sure you're putting the questions in the Q&A box. But yeah, I think as far as where we're at now in the topic, we're good to continue.
Okay.
Yeah.
All right. So I want to talk a little more now on the reserves that we're talking about and the updates on the SIRS. And then I think we're going to talk a little bit about electronic voting. And then will then take some general questions at the end that we didn't cover in the presentation. So on reserves, just in general for both the non-SIRS and the SIRS reserves, if you recall, the general rule of law up to this point was that you needed to have reserves for painting, paving, roofing, and any item where the replacement value was over $10,000. And then, of course, the new SIRS requirements were all the A through G, whatever that listing is of all your structural integrity reserves. So you've got your structural integrity reserve requirements, your non-SIRS requirements, and then both of them had this little catch-all of anything where the replacement value exceeded $10,000. Well, they've now upped that from $10,000 to $25,000, both for non-SIRS and for SIRS reserves. So now, if you're under the $25,000, you will not have to reserve for that item. It's now only $25,000 or higher, and it actually does take into account inflation on an annual basis as well. So keep that in mind. It's been 20-something years that they've had this $10,000 figure. I guess inflation's caught up to us. It's now gone up to $25,000. For structural reserves, very interesting. We thought they would try to make it a little easier for us to fund the reserves. When we were lobbying for this in the legislature last year, what we were hoping that they would do was that we were hoping that they would put in some allowance for associations to either borrow money or levy special assessments without having to take a membership vote, even if a membership vote was required under the documents. Somehow that must have gotten lost in translation, because what they actually did was they now have clarified that we can fund the SERS reserves either through a line of credit or a loan, or through a special assessment, or through your regular annual assessments. But if you do it through a line of credit or a loan or a special assessment, the statute now says you need a majority vote of the entire membership to approve the line of credit, the loan, or the special assessment. So again, I don't know that they've done us any favors on this, and quite frankly, I think they've really done a disfavor to some associations, because I can tell you a number of my condominium associations have documents that do not require a membership vote for a special assessment or for a loan or a line of credit. And now you have the statute being amended to say that you need a vote of the membership for that purpose. I don't know if we can make some arguments that if the documents don't otherwise require that vote, we can go with what the documents say as opposed to what the statute says. Or if we have to try to get the membership vote, but if we fail to get the membership vote, that we can somehow move forward with a board vote. That's something that you're going to have to really work with the association's council to deal with. But unfortunately, they've really messed this up a little bit in the statute, because they basically put an affirmative requirement to obtain a membership vote for a loan or line of credit or special assessment for purposes of funding the reserves. And I would say that this even applies even if the documents didn't otherwise require that membership vote. So I think that could be a problem, but hopefully you'll be able to get that vote of the membership if you're obligated to do that. Special assessments must be included in the annual financial statements. When you do your annual financial statement, you do need to include that. If you do take that line of credit, loan, or special assessment, that must be taken into account in that statement. Pausing of reserve funding. They did give us a little bit of an opportunity to pause the reserve funding under two circumstances. If your condominium building is determined to be completely uninhabitable due to a natural emergency, you will be allowed to pause your reserve funding until the building is again habitable. So that's wonderful news. If your building is in such a dilapidated condition that nobody can actually live there, then good news, you don't have to collect reserves, at least until the building is livable again. Again, I don't know how much that helps that many people, but I guess it's nice that they took that into account. If the building is completely uninhabitable, we don't have to worry about collecting reserves. We can actually worry about doing what's necessary to get that building into a living condition again. And the second one is if you have already had your milestone inspection completed within the previous 2 years, prior to December of 2028, then upon approval of a majority vote of the membership, you may pause or reduce your structural reserves for up to 2 consecutive annual budgets. So I guess the theory being that if you've had your milestone report done and you're doing the work to address the milestone report, I guess they want you to be able to use those 2 years to divert your funds towards that milestone work, as opposed to having to build up your structural integrity reserves. It's giving you a little bit of a break there to be able to divert some funds to the necessary work that needs to be done on the building. But again, after that 2 year period is done of pausing the reserve funding, you're going to have to redo your SERS report and start funding that new SERS level based on that new updated SERS level. And again, that's something I'm giving you the legal obligations, but that's certainly something you're going to want to consult with your structural integrity specialist to deal with if you're in that situation.
And Stephen, a quick question
Yes.
regarding that comment is, does the pause in reserve funding also apply after a recertification?
Does it apply after the recertification? I'm not sure, because it applies when you've had the milestone done and you're in the process of doing the work. So I suppose if that's after the recertification, then yes, I think then that would apply. Basically, what it's saying is if it's prior to December 31 of 2028 and you've had your report done and you're moving forward with the repairs based on that report, then you're allowed to basically take those funds. You're allowed to basically budget for the work to be performed, and you can pause or reduce the funding of the structural reserves, so you don't have to worry about fully funding the structural reserves, and you can use basically so you don't have to fund two things at the same time. You don't have to pour all your money towards the repairs and then double up on the reserve funding. You can pause those reserves for a couple of years. Again, if there are any follow-up questions on that, I would strongly advise your structural reserve specialist or your accountant to address the practicalities of that. But again, from a legal perspective, it's just a little way, I guess, for the legislature to tell us, hey, give you a little bit of a break if you're in the midst of getting your milestone done and having the work done. Use your funds to get that done. Pause your reserves for a couple of years until you are up and running again, and then you can kind of reconfigure and get your new SERS into place.
Thank you,
On
Stephen.
pooling of reserves, again, pooling of reserves, they have clarified that you can pool your reserves. You can pool your SERS reserves. You can pool your non-SERS reserves. You cannot pool them together. That's really the big bright line there. So if you're going to pool your reserves, you absolutely have the right to pool reserves. You've always had the right to pool reserves. They've clarified that you can pool your SERS reserves, but again, keep the non-SERS out of the SERS. If you have to pool, you have to, two separate pools. You can do two separate pools. Have your non-structural pool, have your structural integrity pool, and you can certainly use from within each, but you cannot use one for the other. Siobhan, I think you're going to jump in
Thank
with
you.
some questions.
There is one other question regarding the
Okay.
SERS. So, in relation to the deadline for SERS being extended for a community that has already completed their SERS reporting, are they required to fund reserves based on the SERS in 2026, or can they wait until the updated deadline?
That's a great question. I think, there's certainly arguments to be made that they can wait until the deadline, but here's the problem. And I've made that argument, and then I've been convinced out of it by one of my colleagues who pointed out that the statute also, in addition to extending the deadline, the statute still says that you are obligated to fund your reserves in accordance with the reserve guidelines. So if you've had the report done, and the statute says you must fund your reserves in accordance with the guidelines that have been provided to you, I think there's certainly an argument to be made that you may be breaching your duty if you basically have a document that says you need to fund your reserves in this manner and you don't do it. I think you're opening yourselves up to some potential liability. So I think whether it's truly the legal answer or not, and there's always arguments on both sides. My favorite joke: asked two lawyers the same question, you'll get three different answers. So I know there's differing points of view among all of us on this question, but I would say the safe view is if you've had the SERS done, keep collecting your reserves in accordance with that. Even though the deadline's been extended, I would not wait, because I think you are open to that argument that, hey, you've been provided this information, you've been provided the guideline of how you're supposed to collect your reserves. The deadline for getting that report was extended. It didn't extend the requirement to start collecting in that manner. So if you hadn't had the report done, then you've got the extra time to do the report. But once you've had that report done, I think there are very strong arguments that you need to continue or start collecting in accordance with that report, even though the deadline for getting the report was extended. So it's kind of one of those no good deed goes unpunished. If you actually did it on time, you're now being punished by having to collect in accordance with that report, even though the people that waited on it now have an extra year to do it. But unfortunately, that's the way it goes, and I think that's the safe approach. So if you've had the report done timely, good for you. But I do think you need to continue collecting the reserves in that manner and can't push that off for the additional year.
Wonderful. Thank you, Stephen. Appreciate that. There's a lot of questions on the SERS. Of course, I know that you'll be providing slides, more detailed information that they can look at, later on. There's one more question here that I'd like to ask is, SERS reserves do need to be voted on or to be pooled. They are not automatically pooled once created. They are competent by stature, correct? By statute.
So here's the general rule on reserves was always this, and this is another one where you ask two lawyers the same question, you might get three or four different answers. But the general rule on reserves was always that if you had been collecting your reserves on the component basis, and you wanted to switch to pooled reserves, that the board had always had the right to switch to pooled reserves on a moving forward basis. The determination as to whether or not to pool your reserves was always a board decision and did not need to be a membership vote. What was always confusing was whether you could take those existing component reserves and put them into the pool that you had then created. And the old rule of law was that you had to get that membership vote to move the component reserves into the pool, because you were arguably going to put yourself in a position of using previously component reserves for alternate purposes in that pool. So if you had separately done your paving, your painting, and your roofing, and you wanted to pool them all together, by pooling them and putting them into the pool, you were putting yourself in a position that you might be using your roofing reserves to deal with painting, because now they were all pooled together. So if you had collected them separately originally, you needed that membership vote to put them in the pool, because there was a chance that you would then be able to use them for alternate purposes, because you needed that membership vote to use reserves for alternate purposes. On the SERS, though, so that's still the case for the non-SERS reserves. So if you have a non-SERS reserves and you pool them, the board can decide to vote to pool the reserves moving forward. If you want to take previous non-SERS reserves and put the non-SERS reserves into the non-SERS pool, that requires a majority vote of the membership to move those previously existing component reserves into the new pool. But I think there are now arguments, because it does say that you can go between pooling and component on SERS without a membership vote. I think there are good arguments now that if you had previously collected your SERS reserves as components and wanted to start pooling them, that you now can do that by board vote alone, that you do not need a membership vote. Please double check with your own association's attorney, because again, this is one of these things it's a little bit gray, but I do think that is, I've now been hearing that from at least multiple sources and other attorneys, that at least on the SIRS level, and I think that's the reason for that is because they want to make it a little easier with being able to collect and use the SIRS reserves. So I think on the SIRS side, we are now able to pool them, and I think we are now able to take the component reserves and put them in the pool just by board vote. Non-SIRS, though, I think goes with the traditional rule that moving forward you can do that, pool them by board vote, but if you wanted to take the previous components and put them in the pool, that would require the membership vote.
Wonderful. Thank you, Stephen, for shedding light on that. Last question on this, I think, is a good way to take it back to you is the deadline to complete and submit the SIRS still December 31st, 2025? Did that change?
I believe that it is, yes. I believe that it is. Move the SIRS deadline from 31/24 to 25, yes. So that is the deadline.
Okay.
Stephen, we
Yes.
had a couple of questions coming up about the recordings. I think you already mentioned some of the specificities, but I think we could go a little bit on it
Oh, I
more.
see.
So for instance,
Yeah, I see that.
So the audio by remote, I didn't quite understood him, but get handled like Zoom and the new law. How long must you keep Zoom recordings? How long the meetings recordings need to be maintained, 1 year or longer? So I think we could go a bit deeper
All right,
on this
sure.
part of the law,
Yes,
please.
of course. And I see the few, I've just scrolled down to see a few of the questions. So I see one of the question is, does it have to be posted on the website? One says, does it have to be audio or video or both? And how long do you have to keep it? And then one says, if a board member attends via phone, does that need to be recorded? So those are all great questions. I'm going to lump them all into one big answer here because those are all great questions. All right,
Great.
so
Thank you.
starting off with, I believe they only have to be kept for 1 year. So the requirement is if you're going to have that Zoom meeting and you're opening it up to the members to be allowed to attend by Zoom, you do need to record it. It does need to be kept as part of the official records for up to 1 year, I believe. Again, maybe ask your counsel to double check on that, or if you want to hit me up offline afterwards, I will double check on that. But I do believe it is just a 1 year requirement for the recordings. Now, what it says is it needs to be kept in the association's official records. It does not say it must be posted on the website. I do not believe there is a website requirement. I think it's just a matter of being able to keep it in case somebody requests to see it. So that's an answer to that question. The other part of it is, does the recording need to be audio or video? I mean, the answer is the recording needs to be in whatever format the meeting is being held. So if the meeting is being held like this by Zoom, where it's basically video conferencing, then you need to have a recording of this Zoom the way the way Vinteum is recording this webinar. So if you're holding a Zoom meeting, then you need to keep the full Zoom video conferencing recorded in this same manner. If you're circulating a 1-800 conference number where people can dial in just as a phone conference, then you'll need to record the conference line, but obviously there will be no video component to it. So basically the obligation is to record it in the same manner in which it is being broadcast to the ownership. Now, really great question, because it is a definite distinction between these two things. Remember, before the whole Zoom thing, before COVID, before all this stuff became the big fad, there was always the ability for a board member or even a member to attend a meeting by phone conference. We didn't have an obligation to allow them, but let's say a board member was out of town and wanted to call in. So you'd have your physical presence at the board meeting, and then you'd have a conference line, and the board member that was out of town, they would be on the conference line, and then as long as they could hear everything and you could hear them, they could vote through the phone and so forth. And that, for 20, 30 years, has always been the case, and we used to have meetings where that would happen. This is a great question here. If a board member attends that way, does that need to be recorded? And I think that answer is no. So here's the distinction. If you are holding the meeting in a way where you are providing a Zoom link or some other link to the general membership so that anybody that wants to attend can dial into that conference call or can click on that Zoom link to attend the meeting, you're basically offering a remote meeting. You're offering it to the entire membership to attend by meeting. That, to me, once you've offered that then triggers this requirement that you then have to record it and keep it as part of your official records. If you're just having an in-person meeting where Bob Smith, vice president, decides he needs to call in because he's up in New Hampshire for the summer and he can't make it, and you have one or two board members or three people attending by conference call because they just can't make it, that's not something where you've created a virtual or a remote meeting. That's just I'm accommodating a couple of people by allowing them to call in. That doesn't transform it into a virtual meeting that you then have to record and keep the recording. That's just a couple of people that you're giving them the opportunity to attend by phone call, and like the old rules of the old days, that was certainly allowable. So great question, because there is a huge distinction. And I think that the borderline there is, are we really offering this as a meeting to everybody? Are we distributing a link for everybody to connect to? If we're doing that, then we need to open it up to recording and to being a part of the official records. If we're just saying, hey, Joe can't make the meeting, so here's an 800 number, call my cell and I'll put you on speaker, then that doesn't need to be recorded. Great question.
Stephen,
Okay.
sorry, just one little comment there. So
Sure.
let's say in that same example, they're holding a meeting, like let's say a community room. There's two people joining online because they are snowbirds, traveling, so they need to do that. So it's, even though they still need to have transcripts or minutes of that meeting hold on the community room on their community.
They would still have minutes, sure, but they wouldn't necessarily have to record that because you're not opening it up to the entire membership for a remote meeting. But you're still going to have requirements to keep minutes of the meeting.
Recorded
keep minutes.
and
Yeah.
minutes. Gotcha.
Yeah.
Even though it's in the community room. Okay.
Yeah. Okay, so we covered
Wonderful.
pooling of reserves, we covered pausing of the funding of reserves. In general, on the surge reserves, again, we talked about this when it comes to the milestone reports. They've clarified 3 habitable stories, so it's the same rule for both the milestone and the surge reporting. It's only if you are now 3 habitable stories or more. The surge report must be done by a licensed architect, engineer, or reserve specialist. But again, the same disclosure requirements. If the person doing the surge report isn't intending to bid on any of the milestone repair work, they must disclose that to the association. And then the company bidding to do the work can't have any relationship or interest in the company doing the surge report. So again, basic stuff. Disclose if there's any conflicts of interest, disclose them, or the contracts will be voidable. Really, the last major topic is on electronic voting, and then we can kind of cover any last minute questions or any HOA or other just general legal questions. But on electronic voting, remember the old rule of law was that an association could provide for electronic voting. They were not obligated to provide for electronic voting, and they had to do so on a 14-day notice board meeting where they would adopt this complicated resolution to create the electronic voting, and they would offer electronic voting to anybody in the membership that wanted to opt into electronic voting. If you consented to electronic voting, and you would then start receiving your notices and your ballots by electronic mail, and you could vote electronically. If you did not, then you would still get the normal paper ballot and envelopes and all that sort of stuff. But it was really up to the board as to whether or not to implement electronic voting. Well, they've changed that in a couple of ways. First, they've eliminated the 14-day notice requirement. So now if a board wants to adopt electronic voting, you can do so at just a regular 48-hour notice board meeting. You don't have to give that extra 14-day notice. But now they've added, again, this is going into the whole transparency, into the whole openness, the trending of the law. They've now added a requirement that if 25% of the members petition for a resolution to adopt electronic voting, then the board must hold a meeting within 21 days to adopt such a resolution. So now basically the members can impose electronic voting onto a community. If at least a quarter of the community, 25%, petition for it, they can force the board to hold a meeting to adopt electronic voting. So just something to be aware of. Electronic voting is trending. I know most of my clients are using it anyway now, and it does work very well. But that is something that is now no longer up to. I mean, it is up to the board, but if enough members want to get it together, they can now force the issue and have you adopt electronic voting. What's very interesting and curious to me is they've also adopted an additional way to vote electronically in your condominium elections, which is very. I'm surprised by this because for condominium elections, it used to you have this inner and outer envelope, and they were very strict on making sure that you place the ballot in the inner envelope, and that you put the inner envelope in the outer envelope, and that you sign the outer envelope, and that you couldn't count any vote that wasn't done in accordance with this. But what they've now said is, and this is going to start with all condo elections after July 1st of this year, if you're not providing electronic voting. So again, if you're providing electronic voting, then people can electronically vote or they use the paper ballot. But if you've not adopted electronic voting and 25% of the members haven't petitioned for you to adopt electronic voting, you now have to allow a way in which people can return their ballots by email to you. So, and there's a process to this. So if the electronic voting is not adopted, then what an association needs to do now, when they send out that second notice package with the ballot and the inner and outer envelopes, you will also now need to designate an email address for which the ballot can be returned by a member who does not want to return it in the outer and inner envelopes. A unit owner would be able to scan and email their ballots back to the association without having to put them in the inner and outer envelopes and sign them. However, the email ballot has to contain a space for the owner to type or place his or her unit number and address, a place for them to put their first and last name, so it can't be a secret vote anymore, and it has to include a specific statement in bold type. Waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy but wish to participate in the vote that is the subject of this ballot, please attend the in-person meeting during which the matter will be voted on. So that's straight out of statute. So basically what that's saying is, hey, if we haven't adopted electronic voting, we can still use the same paper ballot, inner and outer envelopes like we've always used. But let's say you're out of country and you're concerned that the ballot's not going to get back in time. I mean, let's put it bluntly, the post office hasn't exactly been the most reliable source of mail in the last year or so, right? We've had some issues and people that have places out of country. I've seen it happen where we were getting ballots 3 days after the election's already taken place. So I think that the reason for this was to address those concerns for people that maybe vote at the last minute or are out of country or for some reason are concerned that their inner and outer envelope are not going to get back to the association in enough time for the election, and they want to scan and email their ballot back. Now they have a mechanism to do that, but they're going to have to waive the secrecy of their vote because they're going to have to sign that ballot when they scan it and email it, and everyone's going to know how they voted because their signature is going to be on their vote. And that's going to sort of act in lieu of the signing of the exterior of the outer envelope. Right before, they still had to sign the exterior envelope, but we would remove the ballot from that, and you would have a secret vote because you could never tie that absentee ballot back to that envelope once they've been separated. So basically, this is sort of a compromise where, okay, if you're concerned that you're not going to get your ballot back in time and you don't want to trust the mail, that's fine. We will allow you now to scan and email your ballot back, but you're going to lose your secrecy. That's the trade-off. You're going to have to sign that ballot so we know that it's a legitimate vote. So we know that it's being signed by a proper voting member for that unit. So that's the trade-off. But it's interesting that that's now going to be an option for condominium associations to do. Again, condo only, not HOA. HOA can still use the electronic voting, but not this type of ballot voting. Do we have questions on that? Because that is the last major topic that I have in the outline, and then we can take some general questions, or if you have any questions, Siobhan, if you think I haven't covered.
Wonderful. Thank you so much, Stephen. So yes, well, two questions regarding the voting. I think you just answered the one. Does that electronic voting apply to HOAs as well, or just condos?
Yeah, just condos.
Okay. And then the second is, what happens when condo associations have difficulty staffing their boards with volunteers because of the confusing group of laws that Florida has implemented?
Have trouble staffing their boards? I mean, if that means that there aren't enough candidates to run for an election, I mean, that can be problematic. The rule in Florida is you don't have to have an election unless there are enough people running to have an election. So if you have 5 vacancies and only 5 people apply, then those people are deemed to be elected, and you don't have to have an election. If only 3 people apply, then those 3 people get seated on the board, and you have 2 vacancies that those 3 people can fill. If nobody puts their name in, well, then you've got a problem because then you have no board, and you might have to apply for receivership. So. If the question is more, what do we do about not having enough volunteers to have committees like the fining committee or something like that? I mean, that's something that you need to have enough volunteers to be able to do fines if you want to have a fining committee. But otherwise, the board is really tasked with running the corporation. You don't necessarily have to have certain committees if you can't get them staffed. But yeah, I mean, unfortunately, apathy is a big problem in many communities, and finding volunteers is a problem. But if the question is specific as to board membership, I mean, there is a mechanism in place that if not enough people submit their names, that whoever submits it, basically they get seated on the board without having to have an election.
Okay, thank you for that. And another question that just came in regarding, it's a little unclear, so I'm just going to read it to you and I'll let you shed some light on it. Is a budget committee meeting the same as all the other committee meetings? Does it have to be properly notified according to FL statutes and property co-op documents to all shareholders, etc., with that same 48 hours offering residents and shareholders the opportunity to attend?
So the answer to that question is going to be different between condo and HOA. So this is where I'll get into a little HOA to tell the difference between the two. Under HOA law, the general presumption is that committee meetings are closed to the membership except for two types of meetings. The architectural board meeting, so if you have a committee, an architectural review board or a committee that makes decisions on owners and their architectural changes to their homes, that meeting under HOA law has to be open to the membership just like any other board meeting. And if you have a committee that's making a final spending decision on behalf of the board, that meeting has to be open to the members. So if the board has created a committee for some specific event and has tasked that committee to spend up to $5,000 on the event, then that committee's meetings will have to be open because that committee is spending final money on behalf of the board, has been tasked to spend money without having to go back to the board. So HOA world, general rule of thumb is committee meetings are closed to the membership unless it's the architectural review board or a committee that's spending money on behalf of the association. The reverse presumption is true for condos. In the condo world, all committee meetings are open to the members unless they've been exempted through the bylaws of the association. So the question being the budget meeting, if the budget committee has to be open, the answer in the HOA world is the budget committee meeting for HOAs does not have to be open to the members unless they're actually spending money. If they're just an advisory budget committee or creating the budget, then it doesn't have to be open. If they're spending money, then yes. But under HOA world, the budget committee does not have to be open if they're just a budget committee tasked with advisory purposes only. Condo world, if it's a condominium association, the budget committee will need to be open to the members like any other committee unless it's been exempted from that requirement in the bylaws. So you can amend your bylaws if you're a condominium association to say that committee meetings are not required to be open to the members. But if you don't have that exemption in your documents, then the statute will apply and it will make the committee meetings open. And that comes into play with the fining committee. You have that three-person fining committee that's going to vote up or down the fine. HOA world, that's a closed meeting. That's not an open meeting. But condo world, that's an open meeting unless it's been exempted in the bylaws. So a big difference between condo and HOA on committee meetings.
Thank you for that. And another question regarding electronic voting. If we are using electronic voting, do we still need to mail the notices, or can they be emails if the owners consent to receive electronic notices?
Yes. So if you've adopted electronic voting, usually what you'll do is when you do the consent form to opt into the electronic voting, you will also include that includes being able to receive the notices by email as well. So once an owner is consented to the electronic voting and to receiving notices by email, then you can just simply email them the notices. The only paper notices that would then go out would be to those who did not consent or opt into the electronic voting. The ones that are still using the paper ballots, then they get their notices by the old-fashioned way.
Okay. Thank you, Stephen. Let's see. Okay, yeah. I mean, there's so many questions here, obviously, coming in about STIRS, about electronic voting. I know we've covered a lot of information.
Siobhan and Stephen, can I give a suggestion?
Yeah.
Sure.
We're gonna definitely talk about an overall the website and portal, what's the main difference, about communications, minutes, Zoom meetings and e-voting. What I would suggest is, because some of the questions Stephen already answered, some of them it's how what we do as a company. Maybe we could start a presentation and Steve could jump in to complement or bring the most legal view of it, because we're gonna show it in practice, how it does it work, how one of our customers do, so you can have a more tangible view of some of these requirements that you just mentioned. What do you guys think?
Yeah, so I think that the questions that are coming in, a lot of it I believe Stephen has covered, and this information, the recording, I believe, right, Stephen, is going to be sent out, or the slides are going to be provided.
The outline that I've been using, I'm going to get that to Peggy, and I believe she's going to distribute that to everybody. And I assume I'm not controlling the recording, but I'm assuming that could also be made available.
Yes.
Okay, excellent.
Wonderful.
Before you do the presentation, though, I'm scrolling through and I can knock out a couple of these.
Awesome.
Fairly simply.
Okay, great.
Yeah.
Awesome. But
Sorry.
Stephen, as I mentioned, we
Yeah.
would love for you to stick around
Oh, I will,
and be with
100%.
us.
Yeah,
Perfect.
absolutely. Absolutely.
Awesome. Thank you.
But just real quickly, I see a question here. HOA, is there a restriction on owners having signs on their property? There's no legal restriction on signage for owners. That's usually in your declaration or your rules and regulations. So for HOAs, I do know that you are allowed to have a signage for your security company within 10 feet of your home, but there's really nothing in 720 that talks about signage one way or the other. That's really going to be a restriction that's dependent on your documents. I see a question here. How about workshops? I assume that's a question about quote unquote workshop meetings and whether they need to be open. Bottom line on this, and again, this is probably, I could spend 30 minutes on this, which I'm not going to, but there really is no such thing as a quote unquote workshop meeting. I know a lot of associations like to have their workshops before the board meeting, but the bottom line is when a quorum of the board is gathered to conduct association business, it is a board meeting and it does need to be opened and noticed to the membership. Again, that's something we can get into in more detail, maybe in another presentation, or if you want to reach out to me offline, we can talk more about it. But there is really no distinction in the law between workshop meetings and regular board meetings. The only time that you can meet as a board in closed session is for personnel matters. So if you're dealing with personnel issues, you can meet in closed session to discuss personnel issues. And when you're meeting with the attorney to discuss attorney-client privilege or litigation issues. So when you're meeting with me to go over any potential legal issues, we can meet in closed session. But beyond that, if you've got a quorum of the board together and you're dealing with association business and not watching the Super Bowl or something like that, that's a board meeting and that's open to the membership. And then the last one that I see here, I see a couple. Okay. On the recertification question, here's a clarification. Referring to Miami-Dade or Broward County recertification, since the statute only indicates that the pause in reserve funding applies after milestone, I think I'm understanding the question. So if you've done the Miami-Dade County or Broward County recertification, I think the general answer is you still have to go through the obligations of the statewide milestone inspection and SERS funding, regardless of whether you have done other recertifications, but you can still use that same information from those reports to use towards the state requirements. So I'm not sure if I'm answering the question as best as you need it, but they're independent obligations. So if you've gone through the recertification already, I think the pausing of the reserve funds really is tied to the state requirements and not to the county or city recertification requirements. And then finally, I see a really great question. What happens if the membership declines or votes down the line of credit or special assessment for the reserve funding? That's a really great question because but you need the funds. These are statewide obligations, which is why we were so frustrated when this law came out that, we were hoping they would say you could get these funds without having a vote of the membership, regardless of whether the documents require it. Now it's basically saying you have to get the vote of the membership, even if the documents wouldn't otherwise require them. But I will tell you, this is my opinion, and again, I would consult with your association attorney, and when you do, make sure they get you an opinion letter in writing that you can rely upon. But my feeling is this. Your obligation overall is to protect the condominium property, to maintain and repair the condominium property. If you don't have the funds to do it, and you have a report that says X, Y, and Z needs to be done, or the building's going to fall down, or it's going to be unsafe, and you need those funds, and you put it out for a vote of the membership, and the membership declines the vote, or you don't get a quorum, or whatever it is, and now you're stuck without the money, my feeling is do it. I don't care if you didn't get the membership vote. Your obligation as a board is to protect the condominium property and get those funds to do the work. If you're asking me if my choice is to defend a lawsuit between not getting a membership vote and having somebody say, well, you didn't get my membership vote to get those funds, so I'm going to sue you for not getting a membership vote, versus, hey, we didn't get the membership vote, so we didn't fund the project and the building fell down, and now I've got 98 wrongful death suits to defend. I think I'd rather defend the lawsuit over whether we got the membership vote or not, as opposed to letting the building get dilapidated and causing harm to people. So again, I think at the end of the day, your overriding obligation is to maintain and protect the condominium property. So I think you try to get the membership vote, but when push comes to shove, if you need those funds, your obligation is to get that work done, as far as I'm concerned.
Thank you so much, Stephen. That's a great response. Okay. I mean, it's just, highlights the reality, of what's available and doing our due diligence, and so grateful for this time here with you today. And I know that, so we're going to transition a little bit and bring Amanda from Vinteum into the conversation so we can learn more about Vinteum and the websites. And I know so many questions around electronic voting and the new laws. And so this is just perfect. What a treat today on this fun Friday. So Stephen, if you had any last thoughts or comments before we bring Amanda into the conversation to do their Vinteum presentation?
No, just happy to be here and I appreciate the opportunity. And I'll defer to Vintium now. But if there's anything you want to ask me specifically on that, or if you want me, I'll be happy to chime in where I feel it's appropriate. But I'm going to go ahead and mute and enjoy the presentation.
Thank you so much, Stephen. We appreciate your expertise. Hi, Amanda. Please introduce yourself. We're excited to hear about your presentation.
Sure. Thank you so much. So, I'm Amanda. I'm the head of marketing at Vinteum. And today we're going to talk about the new website requirements, specifically how Vinteum acts on it and how we can help you with, especially regarding portal, website, communication, voting, Zoom recordings, and much more. So I'm going to leave it with Laura, our account executive, to do that. And thank you so much.
Hi, guys. Laura here. Okay, so this is just like a compliance model that we're going to show you guys. It's more like a visual of what we just, what Steve talked about, of what Amanda spoke to us about. So first off, we're gonna start with the website. So this is again a model on how the website should look like for those communities as well that are required to have one. Remember, 25 units or more. So this is the public-facing website. Remember, a public-facing website, meaning everybody can go in it, not just the residents or not just the administrators, pretty much everybody. You guys can start by having, and again, about a section where you give a brief overview on the community. You could also include photos or, pictures of the community, so to show the landscaping, to show how it looks like. It's really up to each community. You could also, some of our communities, for example, they include the address as well. Again, it's up to you. And if your association or community is having some listings or rentals at the moment, you guys could actually also include that on your public-facing website if you would like that when people search for you on Google or wants to get to know more information about it, they're going to be able to see it right there. There could also be a contact us section where if any of these, external people from the community would like to contact you guys, it's an easier way for you guys to keep track on it. And then again, this is something that some communities that we work with in Florida do as well. They go ahead and share some of the association board members' info here. So it's easier for maybe some of the residents or just the other people to get to know that information. Now, this is again the public-facing website. We are gonna jump now to the portal. All right. So, and in this website, you can actually access the portal by just clicking up here. It will take us to the login page of the portal. Remember, when we're talking about a portal, there's residents and administrators should get a an username and a password. So it's a password protected portal, meaning only residents and administrators again can access to it, not anybody. Okay, so I'm just gonna log in here. Good thing about this portal is that it was especially designed to be user friendly for not only property managers, but especially board members, because we understand a lot of you guys are volunteering. And I'm pretty sure that a lot of, including myself, I'm not a board member, but I'm someone that I'm not a graphic designer. I'm not like a huge pro on creating websites or stuff like that. So this was especially designed to, help maybe like self-managed communities, or it's again, property managers are not like graphic designers and would like to have a simpler way to create or customize or edit this website. So for example, on this portal, there's a really simple way to manage your website right here. So what you just saw in here, this public-facing website, you guys would be able to manage it right here from the portal itself. And it's super simple. It's, user-friendly. And even if your association is not required to have a website, but you'd like to have one, this is super simple for you to manage. So you could just choose templates, colors that go the best or the better with your community, choosing the logo, a nice picture to put in there, edit the about section right here. So as you see, super simple. If you have some classifieds, or if you want to go ahead and like edit the listings or the rentals, you can do it right here. Really simple, to the point, straightforward, and again, super user friendly. So I think we're good here, right, guys, on when it comes to the website and a portal. So now we can go ahead and jump to communications like notices. So remember that, as Steve said, you need to first make sure that all your residents agree to receive online notices or email notices. So after that it's done and they agreed to that, and you guys agree on having a portal and online notices and so on, this portal, it's really good because the communication and the notices are right there. It's the first thing on the front page, so it's very visible. It's easy to access for the residents, even for those who are not, let's say, super tech savvy. And on these notices is where you would send, for example, again, notices of the board meeting that's coming in. You need to let your residents know about these board meetings. And Steve, correct me if I'm wrong. At least 14 days prior to these board meetings or these meetings to happen. So it's good to have these tools here to let everybody know on an email, a push notification, a text message, or even smart calls. Let's say there's a meeting happening within 14 days or next month. And so that way you keep transparency when it comes to communication, and your guys are not only, you're not only just being compliant to this law, but you're also keeping your community engaged, which is the most important thing here. Now, then we cover the the communication and the notices. So you guys see a little bit of how this should work when it comes to let the residents know about events or important things happening or the meetings. We can jump now into one of the most important things that Steve talked about, which is storing this, important documentation. So continuing with the transparency and the security, especially in regards to these documents that must be visible for the residents and or, save or stored in a place where it's easy for your board or for the residents to see. This portal has right here a section that's called, it's real simple, documents. And here's where you guys can actually, organize all these important documents in a super easy way. As you see, we have some examples. Remember, this is just a model, so you guys have a visual idea on how everything that we just talked about looks like. So again, guys, you need a trustful provider to keep this information safe. There's, you guys might have some sensitive information here. There's financial documents, there's ongoing contracts. You could have a list of the residents' info. So you need to, make sure this is safe and it's secure. Now, leaving that behind, when it comes to organizing these documents, for example, we have a folder here that's financial documents, let's say, which is, again, visible for the public. Once you go into this folder, again, this is just an example. This is a model. You guys could have the required documents here. So you can have the annual budget, for example, visible for all. The financial report of the last year, visible for all. The ongoing maintenance contracts, visible for all as well. And the good thing about this portal is that
you can decide who's gonna be able to access these documents.
Yes. So, there's gonna be profiles that are gonna be like permission-based profiles.
Perfect.
So what do I mean with that? I mean that, for example, this document right here is only visible to managers and administrators. So that means that the profiles that are managers and administrators, which could be board members, the accounting, the treasurer, our property manager, they will be the only ones able to see this file. But then the other ones, the residents and or all the other ones, the other profiles will be able to just see the ones that are public. Now, this is a good place to keep, for example, the minutes or the transcripts for those meetings that you're gonna hold. So here you could, for example, have minutes of the last, as Steve mentioned, you got to have the recordings or the minutes for the last 12 months. So for example, here we just on this model we have 4 for the last 12 months. So those minutes you can definitely store them here, and again make them visible for everybody. So it's easier for you guys. So that if residents at some point would like to see the minutes or the transcripts of a specific meeting, you can just let them know. They're right here on the document side. You can go ahead. It's a folder that says meeting documents, and you can just access it right there. So it's easier also for you to not be like looking on the saved files in your computer, and maybe it's a little bit of a mess instead of just keeping everything organized in one place, and it's easier for everybody to access it in just one platform, let's say on their portal. Now, continuing with the meetings. Some communities, not all, I think Steve mentioned this, especially condos. If you're holding meetings, not only on the community room, like a physical meeting, but you're also having online meetings like in Zoom, you would need to have those recordings so that, when residents want to see them, they will be able to see them. They have access to those recordings, correct? A good thing, and because we talk about a lot of Zoom, one thing that I would recommend to you guys is that maybe if you already have a provider or you're looking for a platform, it's good that that platform kind of has an integration to any of these, platforms like Zoom, Teams, Google Meets. So if you are indeed holding these meetings through these platforms, the recordings get uploaded automatically to the portal. So again, it's one task that's already done automatically. So you guys wouldn't have to, get too overwhelmed about how am I going to save this? Where is this recording? Someone asked for it. Who has it? Right? So for example, here on this platform, there is an integration with Zoom. So you would actually create the Zoom meetings in the platform, like here. Once you create it, it will be sent automatically to all the residents or to all the people that's required to be in that meeting. And when residents or board members need to access to that Zoom link or that Zoom meeting, they would have it right there on their portal. They will have it visible, which is what we care about, right? That everything's transparent, that everything's visible for everybody within the community. Now, the cool part of this integration is that, let's say, okay, we're holding the meeting, everything went well, we're all there having the meeting with our cameras, is being recorded, cool. We finished the meeting. Once you press end meeting or you press finish the meeting right now, and everything's closed, the system will automatically upload both the transcripts and the recording of these meetings to the platform. So you pretty much did everything that you needed to do, which is again keeping the recordings and these transcripts visible for residents and for everybody in the community who needs or wants to watch it. It will be automatically uploaded to this platform. So again, it will be visible for all, or depending on how you set up all these permissions. And as you can see, we have the recording of the video right here. So we have the transcript and we have the video. So I would just download it right here, or the resident can just go ahead and download it right here. And this was just a little test we did. And if you want the transcript, you want something that's more like written down. You want to see everything that everybody said at every moment of the meeting. You guys can just go ahead and again download it, and then just open it on a Word or just open it on a Notes. This meeting was really short, so we don't have a lot of text here. But again, it's a really good, it's a really cool way and a good way to have this integration, because everything is basically automatic. So you guys are pretty much saving yourself a little bit of stress when it comes to the recordings, the transcripts of our meetings. Where do we have them? Where do we put them on this portal so that everybody can see it? This is a cool way to, get this stress out, at least for this requirement. And also, just to finish up these for you, on this portal, we also have the capability to hold the board elections if you community agreed on having e-voting. This platform, this portal right here, does count with e-voting, and it does completely comply to all the requirements of the Florida law. So, I think this was just a brief, visual for you guys to kind of have an idea on how everything that we just talked, that Steve just mentioned, well, not everything, but most part of it looks like.
So I think we can answer like a couple of questions.
Sure.
And after that, all of the questions that you couldn't answer here, we have the record of them, so we can definitely have them answered by us or send them to Stephen and Peggy for them to answer later by email, okay? Kathy's question, maybe. Can you tell us what specifically and legally has to be posted on the website for owner viewing?
For condominium associations specifically. And first of all, let me go back and I want to cover a couple of things that I just pulled up the statute, so I want to address a few things that we talked about earlier. First of all, on the issue of the management contract, under condo law, so 718, it says a list of all executory contracts or documents to which the association is a party. So the contract itself does not necessarily have to be posted, just part of a list of contracts that needs to be posted on the website. The other thing I want to clarify, because there was a question about the 7 years versus 1 year, the general rule on records is 7 years. For the recording, it is 1 year. And it does have to be posted on the website. I think I misspoke earlier in that it didn't have to be posted. It says the recording or hyperlink to the video also must be posted for all meetings for the previous 12 months. So that, in conjunction with the 1 year requirement, to me means it's a 12-month thing. So for 12 months, you need to keep the recording, and for 12 months, it needs to be posted on the website. But here's the list under 718. So again, condo only. Here's the list of what needs to be on the website. The current copy of the following documents must be on the website: recorded declaration of condominium and all amendments, recorded bylaws and all amendments, articles of incorporation and all amendments, the rules and regulations, approved minutes of all board meetings over the preceding 12 months. So that's another 1 year thing, just approved minutes for board meetings. The video recording of any video conference meeting that's been recorded for the last 12 months. A list of all contracts to which the association is a party. A list of bids received by the association and summary of bids for materials, equipment, or services for the last year. So again, listing of the bids and summary of bids, not the actual bids themselves, not the actual contracts themselves. The annual budget and any proposed budget to be considered at the meeting. So to the extent that a proposed budget and an annual budget are different, you need to post both of those. The financial report required by the statute and any monthly income or expense statements to be considered at a meeting. All the board members' certifications need to be posted. Any contracts or transactions between the association and any director, officer, or anybody that has a conflict of interest with the vendor. So basically anything where there's a director or other person financially interested in a contract, or any contract regarding a conflict of interest or possible conflict of interest, must be posted. Notices of unit owner meetings and the agendas for the meetings must be posted at least 14 days before the meeting. Notice of board meetings and agenda, and any other document required for the meeting. This is interesting, required by 718.112.2c, which relates to special assessments. So I think there's a misconception among some people that you have to post any contract or any document that's being considered at any board meeting. I think the way that's worded, that's tied specifically to the special assessment. So if you have a special assessment that you're approving at a board meeting and there's a contract relating to the work that the special assessment is for, then you need to post the contract for goods or services that are related to that special assessment that's being approved. But I don't believe it's as broad enough to say that you have to post every document that's being considered at a board meeting. Inspection reports regarding the structural life safety, so the milestones, the SIRS, all those need to be posted. Most recent SIRS report. Copy of all building permits for ongoing construction, and copy of all any affidavits that are required by the statute. So, for example, affidavits of mailings for notices and things like that. And that's the end of the list.
I'd just like to also interject that getting an autonomous website separate from your management company allows you as a resident or a board to be free to make changes to a different management company if you like. Now, what you can do is put the management company link onto your website for payments, excuse me, payments, let's say. So you would link to that, it would go to the management website, and people could make their payments that way if it's a concern about the payments. But every time during the year, I give a hurricane preparedness class. Someone speaks for whatever the topic is, roofing, etc. it always comes up that there is not really a resident address list. And I think this is something that would be really nice to post on your website as well. Because when you get in a hurry and everybody leaves the building and somebody says, oh, did you call Joe? Did you call Sue? All these different people, it's in the cloud. So this way you guys can refer, residents and boards can refer to the list off of your website away from the issue, the hurricane, the storm, the fire. So that's another reason to have an autonomous website. So that's just what I wanted to interject. And Steve, I wanted to ask you, did you mention that the documents and the rules have to be posted?
Yep, all the governing documents and the rules, yes.
All the documents. So it's just a convenient way. You don't have to go look for it in old boxes of files of papers. You got it right there on the cloud.
Yeah, and the other beauty of doing that on the website is, they've also added some language to the inspection of records statute that if you have records that otherwise would be available for inspection already posted on the website, you can basically point those requesting owners to the website. So if you get an inspection request for certain financials or certain minutes, and those minutes are already posted on the website, instead of having to worry about scheduling an inspection within 10 business days, you can say, hey, you might not have realized this, but you can print those directly from our website. They're already posted. And that allows you to kind of streamline that process a little bit too.
Great. This is great conversation for
Thank
this
you,
legal
guys.
update.
Yes. So I'm just gonna leave you guys right here with a little information from our marketing lead, Julia, and then I'll think after that we're just gonna close up our presentation and give you guys a little insight about our company, and then we just gonna be good to go. So Julia, you can go ahead and jump in.
Hi, everyone. Thank you so much, Laura, for such a wonderful demonstration. Thank you, Stephen, for your chiming in and helping us out. And we just want to close this by saying that here at Vinteum, what Laura just showed you, the demonstration that she did, is actually one of our products, which is called Neighbors, Neighbors by Vinteum. And here at Neighbors, we're all about the 3 S's. So it's safe, it's simple, and supportive. So what does that mean exactly? Why is it safe? Because we use the same certificate of security as banks do. So everything is encrypted and protected. All of your sensitive info is protected. And why is it simple? It's because Neighbors was set up to be user-friendly and easy to navigate through all walks of life. So we just wanted to make everything simple for you guys because we know being a board member is a volunteer position, and many of you can feel like it's a lot to take on. So we just want to keep everything simple. It's super easy to navigate, like Laura showed you. And last but not least is really supportive. So I saw a question in the chat asking about onboarding. Yes, we do have an onboarding process and customer support all the week long. So you can reach us in multiple different channels, and we have a personalized onboarding process, which means that we assign a specific member of our team to manage your community and to help you and hold your hand and guide you through whatever issues you might run in or whatever it is you might need. So that is what we do here at Vinteum. And I'm going to throw it back to Laura because she has a very special surprise for you guys who stayed all the way to the end. We thank you for participating. And back to you, Laura.
Thank you so much, Julia, for that amazing information. And yes, just as a last thing here for all of you who stayed here with us, we just have a really special promotion going on right now. In order to, help you guys out, and feel free to contact me, to contact Julia, to contact Amanda. We will definitely help you out with that. And for those of you who have participated on this webinar, we have this great promotion only for you. We'll send it out to all of your emails, of course. Black November promotion that we're having here at Vinteum, up to 3 months for free. So hope you guys take advantage of this. And again, thank you very much for your time. Thank you very much. We know, again, being a board member is a volunteer job, and you guys, assisted to this, not only get the credit, but to learn about this law, learn about how to be compliant, and hopefully this worked to help you guys, feel a little bit less stressed about all of this. So I appreciate your time, and we thank you very much.
Yes, thank you. Vinteum, thank you so much for that gift. This was a wonderful opportunity for us to collaborate together and be able to serve the board members who are on today and our community association managers. Stephen, We value your expertise. You are a pillar in this industry and in this community. So it's a pleasure to collaborate with this legal update with you today. Peggy, thank you for making all of this possible. You board members, you will be receiving your certificate for a credit for this course. So just allow for around 2 weeks. You'll be getting that certificate emailed to you. Of course, we have Peggy who will be sending you out the sponsor sheet so you can have all the resources available for you. These vendors that are on here are here week in and week out supporting you, making this possible. So make sure you reach out to them with any questions that you have. They are a trusted resource in the community as well. We will continue with our webinars. We have a lot of exciting events coming up, so mark your calendars. For November 4th, Benjamin Moore is going to be doing a CEU class for problem solving as it pertains to painting for your building. On November 11th, there is a expo in Miami for condos and HOAs. So November 5th, 11/5. So make sure you check that out. 11/11 is the Biz Now event for associations. You can get those details online as well. On the 20th, Clarkson and Varric Elevator Consultants is going to be presenting a CEU credit for CAMs. So of course, make sure to mark your calendars, make sure that you're subscribed, staying in touch with all that we have going on here at Market Smart. Peggy, thank you so much for this opportunity. Thank you everyone for being here today. It was a pleasure to serve you all. Have a wonderful weekend.